Gentlemen, we are back on the record. Good afternoon, ladies and gentlemen. My name is Timothy Foreman. I'm the hearing officer today. This is in the matter of the recovery of grant funds from the Atlanta Public Library, file number S-LH-18. This matter is being heard on the 6th day of February 2018 in the room 291 of the Howard Building at the hour of 1:55 p.m. Representing the Secretary of State is Mark Christopher Lauro, Deputy Director. Counsel for the APL at Atlanta Public Library, kindly introduce yourself.
Sure. My name is Matthew DiCianni. That's D-I-C-I-A-N-N-I.
Hello, and I'm Steve Mart, M-A-H-R-T.
Thank you. Counsel, I have before me both a motion for particulars and filed by the Secretary of State, as well as a motion for admission of facts to the parties wish to take these matters up during the course of the hearing. Mr. Lauro?
I'm sorry, sir.
I have before me the motion for bill of particulars as well as a motion for admission of facts. Do the parties wish to take this matter up during the course of the hearing?
Yeah,
All right.
we'll put them in the record
Okay.
shortly.
Counsel for the Atlanta Public Library has requested to make a short statement. Please go ahead, Counsel.
Good afternoon, Mr. Foreman. We are here today because we are asking that this court deny the Secretary's petition to have the Atlanta Public Library District repay the Live and Learn construction grant funds. There are two bases for our argument that the library should not be required to repay these funds. First of all, Mr. Foreman, the library never actually violated any of the terms of the grant agreement. And secondly, even if the Secretary's version of the facts, even if their argument were true, the library took measures to cure this breach. This cure was complete and did not thwart the purposes and objectives of the grant agreement. As a result of this cure, the grant fund should not be rescinded. Now, I'm going to explain these arguments in a little bit more detail, but let me first briefly summarize some of the facts that you will hear today. For many years, the Atlanta Public Library District has leased a building in downtown Atlanta called the Union Hall Building. And the library received the Live and Learn construction grant to renovate this building. Now, part of the Live and Learn construction grant application stated that in order to be eligible for these funds, the library must have owned or maintained a long-term lease of the building for which the funds were going to be used. As I mentioned before, at the time the library received the grant, it did not own the Union Hall building, but it instead leased it. And it had maintained a 20-year lease from a company controlled by one of the members of the library board's board of trustees, Bill Thomas. So Mr. Bill Thomas, who's here today and who will testify, controlled the company that leased the Union Hall building to the library. Now, neither Mr. Thomas nor any of the board members were aware that there was anything wrong with this arrangement. They had been told by their attorney that if Mr. Thomas did three things, there would be no conflict of interest or violation of any Illinois statute. And Mr. Foreman, there were three things that Mr. Thomas was told that he needed to do. First of all, fully disclose ownership interest in the building. Secondly, abstain from any discussion or debate about the lease of this property. And third, recuse himself from voting on the lease itself. Mr. Thomas did all of these things, and therefore he and the board was in compliance, was under the impression that they were in compliance with the law. Therefore, they were shocked last summer when they received word from the Secretary of State's office that they might not actually be in compliance with the law. The Secretary claimed, and the evidence will show this, that Mr. Thomas was actually violating the Public Officer Prohibited Activities Act by this arrangement. This violation, the Secretary argued, voided the lease agreement between the library and Mr. Thomas's corporation for the lease of the Union Hall building. There's a provision in Section 3A of the Public Officer Prohibited Activities Act that says that Any violation of the act voids any contract in which there was a conflict of interest. So under their theory, the lease for the Union Hall building was void, which in turn violated one of the terms of the grant agreement, which required grant funds to be spent on a property that the library owned or had a long-term lease in. So once Mr. Thomas and the library learned about the secretary's allegations, they worked quickly to cure any purported violation of the law. Within just a few weeks, the library stopped leasing the building from Mr. Thomas's corporation and providing his company with any lease payments. Shortly thereafter, Mr. Thomas then donated the Union Hall building to the library. He even paid off the $200,000 mortgage on the property with his own retirement funds to make sure that the library took the building free and clear of any liens and encumbrances. A couple of months after that, he resigned from the board. These actions cured any violation of the Public Officer Prohibited Activities Act. So there's a couple of important points to take away from this, Mr. Foreman. First of all, Mr. Thomas was never actually found by anyone, by a court of law or anyone else, to be in violation of the Public Officer Prohibited Activities Act. And the library's lease of the Union Hall building has never actually been found to have been void. Therefore, there's no basis for the secretary to actually recover the grant. At all times, the library maintained a long-term lease of the Union Hall building, and later it owned the building. So there's no evidence that the terms of the grant agreement were ever violated, or at least not evidence strong enough to find that the terms of the construction grant were breached. And as I mentioned before, even if there were a breach of this agreement, this breach was cured completely. The common law of contracts holds, and I explained this in more detail in our response to the motion to the bill of particulars, which I believe we're going to introduce into evidence today, that as long as a party cures a breach in a timely manner, and the other party is not significantly harmed by the breach, and the breach was not done purposefully, and there's a good faith effort made to repair the breach, then the breach is not so material that it should cause an agreement to be rescinded. Here, all of these factors have occurred. Mr. Thomas's breach was innocent and inadvertent, done only because he received potentially bad legal advice from his attorney, and advice that he followed strictly and in full compliance. Mr. Thomas never intended to profit off this arrangement, and never actually did, as he ended up making a significant donation to the library. Again, once Mr. Thomas found out about the potential breach, the library moved swiftly to cure the breach. Within a matter of weeks, the library stopped leasing the building, and Mr. Thomas dedicated the building to the library. The purpose of the contract was not thwarted here. The improvements will still go to help the public. The purpose of the grant will be effectuated. The remedy that the secretary seeks here, rescission, is an extreme one, and one that should only be permitted if a breach is total, substantial, and defeats the purposes of the contract. Here, that did not happen. The purposes of the contract were not thwarted. The Live and Learn construction grant was used to repair the building. And finally, the library will be harmed considerably if it is forced to pay back this grant. It's possible that it will become insolvent, and if it doesn't become insolvent, it will be under a very serious hardship and will be able to do little more than just keep the lights on. So for these two reasons, we feel that the library has a strong legal basis for not having to repay the grant.
Thank you, sir. Mr. Laurel?
As First, the secretary is not the petitioner here. The secretary has made a demand for money that it granted. At the Secretary of State as State's Librarian granted money to the Atlanta Public Library District. And they violated the terms of the grant. And the secretary is therefore allowed, required, mandated by law to demand the money be returned. The petitioner, the library district, is here today to ask that you find that the secretary's demand should not be enforced. Second, this is not a contract matter. The Secretary of State did not enter into a contract with the Atlanta Public Library District. The contract was between Mr. Thomas, who owned the building, while he was a member, not only a member of the Board of Trustees of the district, but an officer of the district. He owned the building and entered into some arrangement with the district so that he could profit by the lease. In fact, Mr. Thomas, as the stipulations will show, was writing checks as treasurer of the district to himself, to his company. And if that's not a conflict of interest, then I can't imagine what would be. The statute does not speak in terms of a breach of contract or a contract arrangement. It does not say anything about curing any kind of breach. The plain language of the statutes shows that if there's a conflict of interest, as defined in the statute, that the grant or the action is void. It's void from its beginning. Now, the only harm done here was to the public trust by Mr. Thomas and the library district, and that cannot be repaired by paying money or handing the building over to the library district. There is no intent required by the statute to violate the statute. And again, the stipulation will show that this advice from an attorney, we don't even know whether the advice was given to Mr. Thomas, not to the library district. We don't know whether Mr. Thomas paid for that advice, but the more important point is that the advice was given almost 2 years after the district entered into the contract with Mr. Thomas. And it's then that they begin scrambling to try to avoid having to pay back the grant money. So all of the facts, we obviously have a bit of a disagreement as to what the facts show, but the facts are set out in the stipulations which we're prepared to present to you today. And then we can argue some more over the law. But the important point we want to make is that, number one, this is not a contract dispute. Number two, there's no intent required. Number three, the action is void from its beginning. So, if I may, I'll put the Secretary's exhibits into the record, and then we'll do the stipulations, and then the petitioner can call their witnesses if they wish. Secretary of State Exhibit number 1 is the request from the Library District for the hearing. Secretary of State Exhibit number 2, and I've shown these exhibits to the petitioner. Secretary of State Exhibit number 2 is the notice of hearing. Secretary of State Exhibit number 3 is a group exhibit. It consists of the copy of the grant application. There's a grant project agreement. There's a quarterly narrative report attached in this group exhibit. Secretary of State Exhibit number 4 is a copy of an agenda of a special meeting of the Library Board of Trustees, December 2014. Secretary of State Exhibit number 5 is a narrative report on the project dated April 2016 regarding the grant. Number 6 is the email from an attorney to Mr. Thomas, written to Mr. Thomas at his place of business using his business email. and that's dated 27 October 2016. Number 7 is a letter from the Office of the General Counsel asking for information regarding the arrangement. Secretary of State Exhibit number 8 is the response of the Library District. Number 9 are minutes of an October 2017 meeting of the Board of Trustees. Number 10 is a letter from the Secretary of State to the Library District making the demand for the grant money. And I've done these in chronological order. Secretary of State Exhibit number 11 is a copy of the November 2017 minutes of the November 2017 meeting of the Board of Trustees. Number 12 is a letter from the General Counsel's office in which it states that there was a meeting held between the petitioner's attorney and the General Counsel's office rejecting their arguments as to why the grant money should not be returned, and again making a demand for the money, or the grant. Number 13 is a small group exhibit. The top page is a copy of a photograph of the building in question. Attached to that is the floor plan. This is a 2-story building. And the grant money was to go to rehab parts of this building. The library, and the stipulations will show that the library was initially supposed to purchase the building from Mr. Thomas. Then they decided that Mr. Thomas would sell the building to some organization called Stone Mission LLC, and that the library would then lease the building from Stone Mission LLC. Some rent payments supposedly were made. The evidence will show that the library district was never able to prove that they paid any money to anyone. They're merely asserting that payments were made, but they have not provided, or did not provide, the General Counsel's office with, like, say, example, a copy of checks making the rent payments. And the rehab was supposedly to the common areas, in other words, the public areas of the building. And in fact, Mr. Thomas had an office on has an office on the 2nd floor. So it's, what the stipulations and evidence show is that there's Mr. Thomas is closely entwined with the building and making a profit off of the lease of the building to the public library. I may have further argument after the evidence is in. We also mentioned that the Secretary of State filed motions for admission of facts, and he also filed a motion for bill particulars. The petitioner responded to those a couple days ago, and we moved not only for the admission of the Secretary's exhibits, but that our motion for the bill particulars and the admission of facts and the petitioner's response to those be made part of the record. We're not going to mark them as exhibits. We don't see the need to do that, but the documents are part of the file. Be made part of the file if the hearing officer allows.
Counsel for Atlanta Public Library, number 1, do you have any objection to the admission into evidence of the Secretary of State's exhibits?
I don't have any.
No. Secondly, do you have any objection of the entry into evidence of the motions and your responses thereto?
No.
The evidence will be admitted, the motions and responses thereto will also be admitted. Were you concluded, Mr. Warren?
Yes, I'll defer to a petitioner and cross-examine after they're finished.
Thank you. Petitioner, you may proceed then.
Okay. Should we just enter our exhibits into evidence here?
If you have additional exhibits, I haven't seen them.
Yes, we do have additional exhibits here. And I'm not sure how you want to mark these as library exhibits or
Petitioner's exhibit.
petitioner's exhibit. Some of these are redundant, but I'm going to refer to these during the examination of Bill Thomas and Kathy Massey and Kathy, so might as well just mark them here. Exhibit number 1, and I've provided you with a copy of these, yes, is an email from Mr. Thomas's attorney to Mr. Thomas explaining what he needed to do to ensure that there was no conflict of interest. Exhibit number 2 is an affidavit from Mr. Thomas filed with the Logan County State's Attorney's Office in July of 2017, just explaining his interest in one of the corporations which owned the building, which owned the Union Hall building. Exhibit number 3 is the letter from the Secretary of State's office to Board President Randy Brooks explaining that the grant funds must be repaid within 90 days. The letter was sent on October 23rd, 2017. Exhibit 4 is a letter and then a deed from Mr. Thomas and his wife donating the Union Hall building to the Atlanta Public Library District. And that letter was dated November 16th, 2017. Exhibit 5 is a letter dated January 31st, 2018, in which Mr. Thomas resigned as a trustee of the Atlanta Public Library District. Exhibit number 6 is a draft letter that was never actually filed or sent by previous district attorney, Atlanta Public Library District Attorney Philip Lenzini, explaining why Mr. Thomas was not in violation of any act, and that was dated, or any statute, and that was dated October 6, 2017. And finally, Exhibit 7 is a letter sent from the Secretary of State's office to the counsel for the Atlanta Public Library District, explaining its position as to why the contract was void between the library and Mr. Thomas's corporation for the lease of the Union Hall building. So those are the 7 exhibits that we wish to enter into evidence.
Mr. Laurel, any objection to any of those 7 exhibits?
Let's go over them one by one. The exhibit number 1 is the letter from the attorney, Mr. Lenzini, which is also already in evidence as one of our exhibits, so we have no objection to that. Exhibit number 2 is an affidavit, I believe Mr. Gianni said it was to the state's attorney's office in Logan County. In substance, it says that I, William Thomas, as president of St. Thomas Corporation, the sole member of Telelogic Learning Company, blah, 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 own what is referred to as the Union Hall building, located in Atlanta. I don't see the point to this. We've already stipulated in the admissions that Mr. Thomas owned the building. So
Your
I guess
objection is irrelevant?
my objection is that it's duplicative and unnecessary. The hearing officer is free to put in the evidence because I don't think it matters much. But the thing that makes it most objectionable is that it's to the state's attorney's office. I don't know what that has to do with this proceeding. In fact, it has nothing to do with this proceeding. Number 3 is already in evidence. It's the October 2017 letter from the Office of General Counsel. Number 4 is this very brief statement from Mr. Thomas and his wife, which says, "I would like to present the attached gift deed to the Atlanta Public Library for the Union Hall building. We're donating the building with no debt or encumbrances associated with it." Totally irrelevant. So for that reason, we object. It has no bearing on the issue here, which is whether there was a conflict of interest at the time the grant was made. If there was a conflict of interest, then the grant was void at that moment. So giving the building to the library district later on is of no relevance whatsoever. The statute was violated. It was violated years ago. And if the petitioner's point is that this donation cures some breach, then we can argue the point of law. Our position is that there's no such thing under the statute as curing a breach. That's a contract law matter, and this is not a contract law matter.
Would I have a chance to respond to that objection, or would you like
You
me?
may respond, let Mr. Lowell get through his first.
Okay.
You're certainly welcome to respond.
Sure. Okay.
And number 5 is a letter from Mr. Thomas resigning his position as trustee. This is a couple of days old. Again, totally irrelevant to the issue here. So we object. And we're just seeing this today. Number 6 is a letter from this is from the petitioner's law firm. No, this is from a letter from Philip Lenzini to the state's attorney's office. I guess I'd like the petitioner to explain what the point of this letter is before I respond.
The point of this letter is just to explain that Mr. Lenzini was giving my client advice, was advising my client and Mr. Thomas throughout this whole matter that he was not in violation of the Public Officer Prohibited Activities Act, and therefore any violation of that act, and we're not conceding that there was one, was inadvertent and done unintentionally.
All right. So our response is that number 1, this letter was again to the state's attorney's office. It has nothing to do with the grant made by the Secretary of State to the library district. It opens by saying, I'll start with a general observation caused by some of the comments in your letter, the state's attorney's letter. We don't have a copy of that letter in evidence. Again, the letter is dated October 2017, a couple of years after the grant application was made, years after Mr. Thomas engaged in the conflict of interest. This is, hindsight is nice, but again, it's just totally irrelevant to the issues here. And so for that reason, we object. Exhibit number 7 is already in evidence. That's a letter from the General Counsel's office to Mr. Mark.
Okay, so our response to his objection to Exhibit 4 is that this document is relevant. It's relevant to our argument that Mr. Thomas cured any breach of the agreement. So, and this shows that he did cure the breach of the agreement by deeding the property to the library so that the library would own it, and that any potential conflict with the Public Officer Prohibited Activity Act.
Can I ask what agreement you're referring to? Mr. Thomas breached what?
The agreement to receive the Live and Learn construction grant.
Well, that was given to the library district, not to Mr. Thomas. Mr. Thomas is the treasurer and member of the board of directors. What?
Mr. Law, if I may, I'd rather get through the exhibits because it sounds like, Mr. Law, you're engaging in an argument, which I think would be appropriate at a later point in time. Let's get through the exhibits and then we can start with the testimony. Rather, unless you want to make additional argument on the exhibits. That's
But
fine.
yeah, that's what that was.
Okay. Did you want to respond to it?
Well, what was your argument again? So you're
Mr. Thomas
No.
is trying to cure a breach, but the breach was made by the I'm sorry, Mr. Thomas didn't enter into a breach, into his contract with the Secretary of State's office. There is no contract. The Atlanta Public Library District violated the statute, and Mr. Thomas violated the statute by their conflict of interest.
okay.
So what is it you're saying he
No,
cured?
so I'm saying your argument is premised on the fact that the contract to lease the building was void because of, the library's contract to lease the building was void because of Mr. Thomas's interest in that contract, and then as a result, that breached the terms of the Live and Learn construction grant agreement because there was no long-term lease of the building by the library. So we are arguing that the terms of the Live and Learn construction agreement, that there be a long-term lease of the building or ownership, were cured when Mr. Thomas donated the building to the library district. So, well, the terms of that grant may have been violated when it was found out, when you contend the contract for the long-term lease of the building was void due to Mr. Thomas's interest in that contract. That breach of the terms of the agreement was then cured by the donation of this deed, by the donation of the building to the library district.
All right, Mr. Foreman, Mr. DeGianni mentioned a long-term occupancy requirement. The grant requires that the library enter into the long-term occupancy of the building in order to qualify for the grant, whether that be by purchasing the building or leasing the building. But it has to be, they have to occupy it in the long term, which is defined as at least 20 years, in order to receive the grant. That's what he's referring to.
Anything else from either party?
No,
I'm going to withhold or uphold the objection to number 6 because I find a couple of things. Number one, as I understand counsel, is letter was never sent, correct? It was never sent to Mr. Wright, correct?
that's correct, yes.
Just glancing over, it seems to be more a colloquy by Mr. Lenzini with himself trying to convince Mr. Wright of something, I'm not sure which, but given the fact, as Mr. Laura pointed out, we don't have the original correspondence from Mr. Wright, I can't really consider this proposed return correspondence by Mr. Lenzini because I don't know in what context it could possibly exist without having the original letter. So I'm going to uphold the objection of the Secretary of State to that letter and mark that as irrelevant and inadmissible. I'm going to allow the rest of the exhibits proffered by the Atlanta Public Library for the simple reason that I think as we go through the evidence, I can give them or accord them the proper weight based upon the testimony that is presented by both parties. Thank you, Jim.
Very good. Thank you, Mr. Foreman. Okay, we're ready to call our first witness here, Mr. William Thomas.
What would you like?
Mr. Thomas, you can sit right there. I think.
Please raise your hand. Raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth, sir?
I do.
Thank you.
Mr. Thomas, could you please state and spell your name for the record?
Sure. William Michael Thomas, William Michael Thomas.
Mr. Thomas, let's just briefly discuss your background here. Where do you currently live?
Illinois.
Okay, and approximately how long have you lived in Atlanta, Illinois?
Going on 34 years.
Okay. And have you been involved in community service in Atlanta?
Yes.
Okay, could you just briefly describe that work?
Number of different organizations over the years: Atlanta Rotary, Atlanta Eminence Christian Church, Atlanta Historical Preservation Council, Atlanta Planning Commission, Atlanta Historic Commission, Atlanta A-Team, Atlanta Betterment Fund, Atlanta Economic Development Commission.
Mr. Thomas, are you familiar with the Atlanta Public Library District?
Yes.
Have you been involved with that organization?
Yes.
Could you please describe your involvement with that organization?
I was first elected to the board in 2005, and I've been serving ever since.
Okay. And did you ever hold a position with the board of directors?
Yes.
What was that position?
Treasurer.
Okay, and can you just briefly describe what the role of the board of directors is?
The board of directors sets policy and maps out strategic planning for the library in order to achieve its goals and mission.
And can you briefly describe what your duties were as treasurer?
As treasurer, I worked very closely with library directors to put together an annual budget designed to meet the goals and mission of the library, and then monitor that budget throughout the year.
Now let's just briefly discuss your occupation. Where are you currently employed?
I work for Teleologic Learning Company.
I'm sorry, go ahead.
Okay, and I'm also employed as executive director of the Logan County Economic Development Partnership.
Okay. What does the Teleological Learning Center do?
That's a company that designs and produces online training, primarily for government and military clients.
And are you aware of a building called the Union Hall building?
Yes.
Where is that building?
That building is located at 114 Southwest Arch Street, Atlanta.
And what's housed in that building?
Office space, programming space for the library. There's a small sound studio. It's a two-story building.
Okay. And who is the current owner of this building?
The Atlanta Public Library District.
And who owned this building prior to the library district?
Teleologic Learning Company.
Okay. And how long has the library used this building?
The library's had access to the building for various programming purposes, for dinner programs, evening events, that sort of thing, going all the way back to 2015.
Okay. So the library has used the Union Hall building since 2015. Now, when Teleologic used to own the Union Hall building, is that correct?
Correct.
Now, how was the library able to gain access to this building if Teleologic used it?
I let them use the space.
Okay. Okay, and does Teleologic still own this building?
No,
Why not?
because my wife and I gave it to the library.
Okay, and when did you give it to the library?
That was in October of 2017.
Okay. Now, did you ever have any concerns about a potential conflict of interest in letting the library use a building that your company owned?
Yes.
Could you please explain what those might have been?
When the library decided that it wanted to lease the building, that's when the concern raised. The first thing I did was meet with Randy Brooks, the chairman of the library board, and talk with him about the fact that two things needed to be addressed. We needed to find out whether or not it was even possible for the library to lease from Teleologic, and if so, how you went about doing that.
So you said you spoke to Randy Brooks about the two
Yes.
concerns that you had. What happened after that? Did you speak to anyone else about?
Yes.
Who did you speak to?
On behalf of the library, not on behalf of myself as an individual. As treasurer of the library, we contacted the library's lawyer and said, the library's interested in leasing the building. Is that possible? Because I sit on the board.
Okay. And what did Mr. Lenzini, or who was the library's attorney, I should say?
It was Phil Lenzini.
And what did Mr. Lenzini tell you about the library potentially leasing the building from Teleologic?
He indicated that in order for there to be no conflict of interest, three things needed to be done.
Do you happen to remember what those three things were?
Very well. Disclosure of ownership of the building needed to be made. I personally would not be allowed to and should not participate in any discussions or debate on any matters regarding leasing the building during board meetings, and I would not, should not vote on any matters related to leasing.
And Mr. Thomas, did you fulfill all three of those conditions?
Yes.
Did Mr. Lenzini ever send you an email explaining this?
Yes, he did.
Could you please open up that black binder there and take a look at Exhibit 1? Could you please take a minute to read over that document?
We've stipulated to the document.
Okay, but I just want to...
Yeah, I'm familiar with this.
You're familiar with that? And that's the email that he sends to you?
Correct.
Okay. Could you please take a look at Exhibit 2 in that binder?
Mm-hmm.
Okay. Have you seen that document before?
Yes.
Could you please explain what it is?
It's an affidavit that Phil Lenzini suggests that I have put together and signed and filed with the Logan County Courthouse, not the state's attorney, but the courthouse. Okay.
Thank you for clarifying that. And is this just further evidence that you fully disclose your interest in the building?
Yes.
Okay. Now, did you ever learn that perhaps your attorney's advice might not have been correct?
Yes.
When was that?
Learned of it authoritatively when we received the letter from the Secretary of State's office indicating that there was a conflict of interest.
Okay, do you remember when you received that letter?
I believe it was October 2017.
Okay. Now take a look, please, Mr. Thomas, at Exhibit 3. Is that the letter you were referring
Yes.
to?
Yes.
Okay. So after you received that letter and you learned that your actions might, there was a question whether your actions might have violated the Public Officer Prohibited Activities Act, what did you proceed to do then?
I went home and talked with my wife about the issue, and she and I came to the decision that because we wanted and want the library to have the building to use for programming, that we would donate the building to the Atlanta Public Library.
Do you remember when this was that you donated the building to the Atlanta Public Library?
She and I talked about it in October of 2017, and then it was officially, I believe the gift deed was in November and presented at the library board meeting.
Okay.
In November of 2017.
And Exhibit 4 is a copy of that gift deed, is that correct?
Yes,
Okay. So you discovered that there might have been a potential problem in October and 23rd, that's correct?
correct.
And then you donated the building to the library November 16th,
Right.
correct? So that's what, not even 4 weeks, right?
No,
Okay. And once you donated the building to the library, neither you nor any company you controlled was had any interest in the building, correct?
that's correct.
And you weren't receiving any money from the library, is that
No.
correct? Okay. And then, do you still serve on the library board?
Not as of January 31st.
Okay. And what happened on January 31st?
I submitted a letter of resignation to the library.
Of this year, sir.
Yes, of 2018.
And that, if you take a look at Exhibit 5, Mr. Thomas, have you seen that document before?
Yes,
And what is that document?
that's my letter of resignation to the Atlanta Public Library.
Okay.
The correspondence says 2018. Did you mean 2017, sir?
No, 2018.
So
I
you
stand corrected. Thank you.
you resigned from the Board of Trustees literally last week?
Right.
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 Thank you, sir.
Yeah, I'm sorry.
No, that's all right.
Okay. And why did you resign from the Board of Trustees?
As it states in the letter, the sole and only reason I did that is because I still wanted to be able to rent office space from the library, and when it was explained to us by our current lawyer that that would not be possible as long as I was still on the board, I resigned.
Now, Mr. Thomas, you have never been found to have violated the Public Officer Prohibited Activities Act, correct?
Correct.
Right. And to your knowledge, the agreement by the library to lease the Union Hall building has never been found to be void, correct?
That's correct.
Okay. Now, Mr. Thomas, I'm just briefly want to talk to you about the Live and Learn construction grant. Are you familiar with that grant?
Yes,
What was that?
that's a grant that the library applied for.
Okay. Do you remember approximately when it applied for that grant?
I believe it was the very beginning of 2015, January 2015.
Okay. And why did it apply for that grant?
The intent of the grant was to help address a problem the library was having with not having adequate space for the programming that it wanted to do. So it was going to solve that problem by refurbishing the space and doing programming in the Union Hall building.
Okay. And based on your knowledge as treasurer, how much money did the library receive from the state?
The state grant award was $25,000.
Okay. And has it spent those funds?
Yes,
I know you said that it was to, the money was spent on refurbishing some of the rooms where the programming took place. Do you remember specifically what was done?
sure. One of the things, roof repairs were done. The library also owns the building which is adjacent to and abuts up against the Union Hall building, so that's where the museum is housed. So in order to make for easy access between those two buildings for programming purposes, doors were cut into the walls. Those are the main things.
Okay. Now, as treasurer, you were aware of the library's finances and its budgeting, correct?
Yes.
Okay. Now, based on this knowledge, what would be the financial consequences of the library having to repay this grant?
The library has the funds to repay the grant, but it would impact the library's ability moving forward to do the kind of programming that needs to be done.
Okay. And do you have any other knowledge of the negative? So would it would have a pretty negative impact on?
Yes, it would. The library would have a building that it would be very difficult to do programming in.
Okay. Okay, I have no further questions, Mr. Thomas. Thank you.
Uh-huh.
Mr. Lowe?
sir. You said you work for Teleo, is that how you pronounce it? Teleologic?
Yes.
And do you have a position,
I'm
title?
CEO.
And how many employees work for you?
I am, not only work for Teleologic, I'm working very hard to downsize and retire from Teleologic, so it's myself and one employee as of.
And what's the at its highest number, how many
Oh.
employees did you have?
There
What's
were
the most
over
number of
20.
employees you've ever had?
Over 20.
More than 20, and now there's one. And it's correct that as treasurer of the library district, you were writing checks to yourself, to Teleologic. Or did you in fact do that?
No, checks were written, they were signed by the president of the board, not by me.
Okay, so explain to us, you're the treasurer, what is your role in, well, first of all,
Sure.
didn't in fact the library pay rent
Yes,
for
that
the
is
building?
true. Yes.
But you've never produced a copy of any of the checks, is that correct?
No,
So what's the process? If you were to write a check, how does that work? You said,
we have a bookkeeper who writes the checks. Yes, actually physically
physically writes the checks.
creates the checks, and as soon as the lease between the library and Teleologic was put into effect, whereas it would be normal protocol for me to sign a check, that was changed, and the library board president instead signed those checks.
But we don't have a copy of any of those checks, right?
Okay, objection to that. What do you mean by we? It's not clear.
There is no you do not have a copy of any of the checks to put into evidence that we can examine. We being your attorney or me?
Okay, my only response to that is in the statement of facts that I signed off on, it clearly shows that 9 different checks between December and September were written.
Yes, but you cannot produce a copy of the checks.
If you give me time, I can.
Well, the hearing is today, sir.
Okay, well, I was never asked to do that.
All right. Now, you said that Mr. Lenzini was the library's lawyer,
That is correct.
and how do you know that?
Because I sit on the library board and we pay him to write ordinances, etc. for us.
All right. Now, let's see. We're talking about an email that was sent to you, correct, by Mr. Lenzini?
That is correct.
And it's not copied to anybody else. This is to you at Teleologic, correct?
That is correct.
And this email is sent to you several months after the grant application was given, correct? Now, apparently this email was written in response to another email.
It was written in response to a phone call.
All right, and in fact, it says the email is to confirm our phone conversation. So you called him to find out whether you were in any jeopardy?
I called him to find out if it was possible for the library to rent the Union Hall building
To you?
to Teleologic, yes.
All right, now this affidavit to Logan County, what does that mean? I mean, what did you do with this affidavit? Who did you give it to?
I can explain, if you want me to,
I
go back
want
to
you to
the
answer my
story.
question.
Sure.
Who did you
Okay.
give the
It was filed with
affidavit to?
the clerk of the Logan County Court.
And was that pursuant to any arrangement or agreement between you and the state's attorney's office?
No. It was done at the advice of Mr. Lenzini.
So it was Mr. Lenzini's advice to go ahead and file this affidavit, thus publicly disavowing any interest in the building, is that correct? Is that your intent?
The sequence of events was when Mr. Lenzini explained the three things that needed to be done. The first was disclosure of ownership, and at that time, when I was first given that advice, Mr. Lenzini relayed to me, and that's already been done because Teleologic's name and your name are on the lease. Subsequently, when I asked Mr. Lenzini further about, are you sure we're doing things correctly, he said you should file an affidavit.
And again, this is several months after the grant was application was made for the grant and the grant was issued, right?
That's correct.
Okay. I believe the stipulation shows that the first action of the library to purchase the building was in 2014, is that correct?
Objection, lack of foundation. He doesn't have a copy of the stipulations, and there's no evidence that he has ever seen them.
I took that more as a statement of what he was looking for than anything. Mr. Laura, is there something you wanted to show the witness?
Let's see. All right, so the admission of facts, in fact, I'm reading from the petitioner's response, paragraph number 1. On or about 18 December 2014, the agenda for a special meeting of the Library District states that it was convened to discuss the Union Hall project. You're listed, Mr. Thomas, as being present at the meeting, correct?
Correct.
Excuse me, Mr. Laura, counsel for APL, I don't have a copy of the response.
Oh, sure.
If I could get that, that would be wonderful.
Yes, yes, Mr.
Thank you.
Yes, thank you.
Thank you, Mr. Laura, please.
The minutes reference a need to move forward with the lease or to apply for a grant from the Secretary of State. This contract will be null and void if grant money is not received from the project. Mr. Thomas abstained from the vote. So you were in on the purchase of the building from the very beginning. You were aware of the purchase of the building from the very beginning.
Yes.
And isn't it true that the other members of the board knew that you were the owner of the building?
Oh, yes.
So, while the minutes say that the minutes reference a need to move forward with the lease to apply for a grant from the Secretary of State, isn't it true that this arrangement, this agreement, was not disclosed to the Secretary of State in the grant application? The Secretary of State didn't know that you owned the building when the application was made. You did not disclose that to the Secretary of State.
I would have to look at the application itself to be able to answer
Okay.
that question.
Well, the hearing officer can look at it. I'm showing you what I marked as Secretary of State Exhibit number 13. This is a photograph or Xerox copy of a photograph of the building. Is that correct?
That's correct.
And if you wouldn't mind looking at the floor plan and telling us whether that's an accurate floor plan,
That's
first
accurate.
and second floor.
Yes.
And you said that the
Yes.
and there's in the middle of each floor, there's a substantial amount of what you would call open space or common area, right? And your office is where? On the second floor? Okay. You've pointed out southwest corner, there's a conference room and then office space, and
Correct.
that's your office space.
Correct.
Is there also a restaurant in this building?
No.
Okay, Mr. Foreman, I'm going to object to this line of questioning. This is beyond the scope of the direct examination, and frankly, I don't see how a restaurant is relevant.
I'm going to sustain your objection.
You said that there was work done to the roof
Correct.
and a door was cut between one building to the other.
2 doors. One on the first floor, one on
All
the
right,
second.
so that enhances the building itself, increases its value.
In terms of the ability to do programming that involves the adjacent building, yes.
Mhm. Did you decide to donate the building pursuant to some agreement with the state's attorney's office, perhaps?
No.
Um, Have you discussed this matter, or has the state's attorney discussed this matter with you?
No. That decision was actually done at the impetus of my wife.
Well, okay, I'm not gonna speculate. We'll assume that's correct. Okay. Now we get it.
Anything further? You finished, Mr. Earl?
I think for
Okay, I just have just a couple of questions here, Mr. Thomas, on redirect. Now, council indicated that Exhibit 1, you want to turn to that, was an email sent by Mr. Lenzini to you. Do you remember that?
Yes?
Okay. Now, based on your personal knowledge, was the rest of the board familiar with what the contents of that email said?
Yes.
Okay. And just, again, just based on your personal knowledge, did the board consider anything you had done to be improper?
No.
And again, that was due to Mr. Lenzini's advice, correct?
Yes. The reason I asked Mr. Lenzini to put in writing the substance of the phone call we had was because we wanted it presented to the rest of the board. And it was.
Okay, I have no further questions, Mr. Thomas.
Recross, please. Do you have some evidence, some documentation to show that you passed this on to the board? Is it in your minutes of a meeting somewhere? Do you have a copy of the email, of you forwarding the email?
Not with me, no.
So is that
It should
is
be
that-
in the minutes of the board.
Okay, so email is from October 2016, and it was disclosed, you gave this information to the board when? How soon after?
The very next, whatever the next library board meeting would have been from the date that the email was.
How often does a board meet?
Board meets once a month,
Okay.
so I don't remember the exact date of that
Okay,
meeting.
so it would be November, December 2016.
More likely November.
Okay. All right, thank you.
Thank you, Mr. Thomas.
Your excuse. Thank you, sir.
Do you need me to go somewhere?
You can
Or-
stay here
Okay, I
if
didn't know
you
if I
want.
could be here
Yeah.
while Kathy was here.
Oh, yes, since you're not going to testify again.
Okay.
Yeah,
Mr. Earl, do you have an intent on calling him back by any chance?
No.
Okay, thank
Yeah,
you.
that's a good question. Should we get Kathy then from the
Yes,
garage?
she's in the reception area.
Okay, I'll go get her.
Ma'am, would you please raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you, ma'am. Counsel.
Okay. Miss Machado, could you please state and spell your name for the record?
Sure. Catherine Machado, Catherini. Last name is Maciariello.
And Miss Machado, are you familiar with the Atlanta Public Library District?
Yes,
Have you been involved with that organization?
I'm the director of the library.
Okay, and can you please briefly explain your job duties as library director?
Sure. I share responsibilities with a counterpart who takes care of the museum. I take care of the library. And that job includes managing the collection, adding books, disposing of books, running all of the programs that we do each year for the public, preparing all the documents for board meetings, interacting with the public, working on policies, et cetera, representing the library to the community.
And how long have you held this position?
I've been director since 2014. Prior to that, I worked as program director. So I just did the management of programs for about a year before that.
Okay, so you started working there roughly 2013.
Yeah.
Okay. Now I want to ask you a few questions about the Union Hall building. Are you familiar with the Union Hall building?
Yes.
What is that?
Well, the building is at 114 Arch Street. It's catty corner from the library and adjacent to our museum.
Okay. So that's a building in
Atlanta.
downtown Atlanta, yeah. And you briefly alluded to this, but what is the Union Hall building been used for?
Well, when I first became involved with the library, it was an office building. And then as we moved into the Live and Learn project and this recent project, we began using the building for library programming as well.
Now, does the library, has the library leased the Union Hall building?
Yes.
Do you know from whom?
We leased first from I think Stone Mission, John Yates is the name of the proprietor of that company. I think we leased from him for 3 months, and then we leased for 9 months from Teleologic Learning Company.
Okay, and do you remember when that lease started?
Let's see, with Teleologic?
Yeah, yes.
I think December of 2016,
Okay.
I believe.
Okay. And do you know who the owner of Teleologic was at the time?
Yeah, William Thomas.
Okay. And that's the Mr. William Thomas that serves on the Board of Trustees,
Yes.
right? Okay. Now, based on your personal knowledge, serving as library director, did you believe that there was any problem with the library leasing the building from a company controlled by Mr. Thomas?
No.
Why? And can you just please explain why that was?
Well, before we went into this arrangement to either purchase or lease the building, Mr. Thomas actually was concerned, or not concerned, but wanted to make sure that it was all fine to do since he was on the board. So he had contacted our lawyer at the time, Phil Lenzini, to get an opinion about that. And we received an opinion from Mr. Lenzini that it shouldn't be a conflict provided that he followed some rules. And this was consistent with my experience in working in nonprofits over the past number of years. So we went with the information we received from Mr. Lenzini.
Okay. And do you happen to remember what Mr. Lenzini specifically told Mr. Thomas to do?
He told him that he would need to disclose ownership of the building, that he would need to abstain from any discussion, and not participate in any discussion around the lease or purchase of the building, and not to vote on anything that was related to the building.
Okay. And based on your personal knowledge, did he do that?
Yeah, absolutely.
He did all three of those things.
As far as I know, in fact, he stopped even coming to board meetings so as to avoid any, perceived conflict.
Okay. So, did you ever become aware that perhaps Mr. Thomas might not have, there might have been a conflict of interest in what Mr. Thomas was doing?
Well, initially, there were questions raised by members of the community, I believe, in July and August, at our July and August board meetings in 2017. And at that point, we really just let people know that we had the opinion from our lawyer that as long as, Bill did those three things, that we were in compliance and it wasn't a problem. We continued to believe that until, probably close to the end of September, I think, when August 22nd, we got a FOIA request from the state's attorney. And then on September 29th, the state's attorney, Jonathan Wright, wrote a letter to our attorney outlining concerns about conflict of interest. And that's the first time, beyond just general questions and comments, that anything authoritative was said to us about potential conflict of interest. It was really September
Who has that letter?
29th.
Ma'am, who has that letter?
I'm sorry, who has?
Where's the letter? You said Mr. Wright wrote a letter to you folks. Where is that?
Do we have it here?
You have that
I have it in, I have it in my possession at the library. I don't know if we have it here.
Mr. Laurel, was there a request made for correspondence between the parties? By the Secretary
This
of
was a
State?
letter from the state's attorney to, yeah.
I'm asking Mr. Laurel if he had requested documents that would contain
The
that.
general counsel asked for documentation explaining the arrangements in the building. I don't know whether it was disclosed until today.
Yeah, and this letter that came was the letter from the state's attorney to our attorney after basically establishing that Mr. Lenzini was the attorney of record, that he was indeed representing us, and outlining his concerns about conflict of interest.
And just to be clear, this was September and October of 2017.
2017,
2017.
yes.
So this past September and
Yeah.
October. Okay. Now, after you learned that perhaps there might have been a conflict of interest, can you please explain what the library did after it learned about this?
Okay, yeah, as soon as we saw that letter from the state's attorney to Phil Lanzini, our board president decided to actually meet with the state's attorney to try to get a better idea of what our, if any, our vulnerability was. And so on October 4th, I believe, he met with the state's attorney and came back from that meeting feeling that this was something that we should take care of. And so at our subsequent board meeting on October 12th, we actually rescinded the original motion to purchase the building, and we ceased making lease payments. And in that same period of time, Mr. Thomas had notified our president that he would donate the building, and that announcement was made at the same meeting. And we did that to make sure that even though we had rescinded the intent to purchase, that we were maintaining continuity of ownership of the building, because that was part of our grant requirement.
And do you remember when this donation occurred?
The announcement was made on October 4th that would happen, and the paperwork was prepared during the next month, and the donation was made at our board meeting on November 16th, the presentation of the deed to the building.
So this was made right after you learned from that there might be a conflict of interest, right?
Right.
Okay.
Yeah, I mean, it really was from the 29th of September to October 12th.
Okay. So it's fair to say that the library acted very quickly to bring itself into compliance with the law. Is that right? If
So,
right. Okay. Now, Ms. Macchiarello, are you familiar with a meeting that the representatives of the library might have had with the Secretary of State's office toward the end of 2017?
right. After we had received, I think on October 23rd, a letter from the Secretary of State's office telling us to repay the grant. And then because that letter came after the donation was announced and just around the same period of time, we asked for an informal meeting with the Secretary of State's office so that we could inform them of that prior to requesting a formal hearing. That meeting was held on December 4th.
Okay. And at that December 4th hearing, did the Secretary of State ever say anything about the library's potential violation of the act, specifically whether it was done intentionally or not?
Oh, well, they, in the letter, the follow-up letter we got reiterating that we needed to repay the grant, they did say to us that they believed that we didn't do anything intentionally to violate the Public Records Act.
Could you please open up that book there to exhibit number 7?
Gosh, I'm gonna need my glasses.
Oh.
Yeah, okay.
Okay, can
Yeah, I
you
can see.
you can read? Okay. Is that letter you're referring to?
Yes.
Okay. Now, Ms. Macchiarello, I want to briefly discuss what the repayment of the Live and Learn construction grant would do to the library district. Now, as library director, are you familiar with the library's budget and finances?
Yes.
Okay. And how much money did the library receive for the Live and Learn construction grant?
$25,000.
And what were these grant funds used for?
Specifically for renovation of the Union Hall building in order to make it practical for our programming use.
Okay. And do you know specifically what was done with it?
Yeah, what we've done so far is open two doors. The building is adjacent to the museum, which was one of the reasons we wanted to use this building, because it's a natural addition to property we already own. So we made two doors, one downstairs and one on the second floor, to connect the two buildings together and to make it handicap accessible. We also did extensive roof repairs and some tuck pointing that we discovered needed to be done at that same time, and we repaired a back door to the building and did some renovation on a room that we use for activities and exhibits there.
Okay. And has the library used all of this grant money?
Yes.
Okay, so all $25,000 of this grant money has been spent. Okay. And has the library relied upon the grant in terms of its planning and budgeting?
Well, it's not a direct impact on our budget because they're not operating funds, they're capital funds. But it certainly, we relied on the grant money to help create the space that would allow us to expand our programming, and that does have an effect on our budget and our activities.
So would the library suffer a hardship if it were required to repay the grant?
Absolutely.
Can you just briefly explain why?
Well, we're really small. I mean, our entire budget is, $180,000, and most, a good portion of that is from tax revenue. It takes us a long time to save $25,000. In fact, I think we have CDs of about $15,000 right now. The other money that we have set aside is money that was received in matching funds for the grant. So I think, we feel morally that if we have to pay the money back, we need to ask those donors if they want their money back as well, which is $30,500. If they want their money back, then we don't have enough money to pay the grant back. If they allow us to use their money and we use some of it to pay the grant back, the unfortunate thing is then we don't have any money to finish the project, and there's still, the total project cost was about $62,000, and we still have work that we plan to do, and we won't be able to do that, hence we won't be able to do all the programming, and we'll have to go back to trying to put aside a little bit of money each year to save up. So it has hurt, and obviously it's hurt our operating budget this year because of all the added expenses surrounding everything.
Sure.
Legal fees and all kinds of, stuff like that. We've already had to put freezes on purchasing materials. We may have to be laying off staff for a while, depends
Okay. So
what we have to do to come up with $25,000.
Right. So the library would be able to basically just keep the lights on, and that's about it if it had to repay the grant. Okay. No, I just wanted to return to something briefly you said before. You noted that the library was leasing the Union Hall building. Has this lease ever been found to be void, to your knowledge?
Well, when we met with the Secretary of State's office, that was sort of the premise, that when we made the grant, it was part of the grant, that because there was a conflict of interest, that meant that the lease would have been void. We didn't ever have any knowledge or any indication from anybody that the lease was void. We continued to behave as if it were legitimate and active, and we never had any, I think as late as August we had an extension of our grant, so we really never had any indication that things weren't going along as we planned.
Okay.
That they should.
Okay. All right. That's all I have.
Okay.
Thank you, Council. Mr. Laurel?
Your name is pronounced Machado.
Machado, pretty good.
Beautiful. All right, so you've been employed by the library since when?
Yeah, as director since 2014, July of 2014. And then the year
So you were
before-
director at the time that you submitted the grant application. And that was in December, January of 2015, correct? That's 14, 15. And isn't it true that you knew that Mr. Thomas owned the building at the time?
Yes,
And I think I heard you say that before you submitted the grant application, you checked with an attorney as to whether it would be legal. And you
no,
were-
no. That was in 2016. I believe, I didn't do that. That was, I think, the email that we received from Phil was from 2016, I believe.
Okay, so several months, almost 2 years after
Right,
you submitted the grant application.
yeah.
And was that your first inkling that there might be something wrong? Or did you?
I didn't, I mean, we didn't, honestly, we didn't think that there was anything wrong at that
Really?
point because Mr.
Hold on a
Lin-
second, hold on a second.
Yes,
Mr. Thomas is a member of the board and your
Right.
treasurer.
right,
He owns the building.
right.
You're gonna, your original agreement was to buy the building from him, correct?
Correct.
You didn't see any problem there, none whatsoever.
because-
Objection, asked and answered. She said she didn't see any problem with it.
Is that correct, ma'am? I want to be clear.
Absolutely, because
Okay.
we felt that it was completely transparent and we were abiding by,
And you said that questions were raised, what, in the community?
community at our July and August board meetings in
Okay,
2017.
This is members, these are members
Members of
of,
the community raised a question about conflict
Okay.
of interest, and that was.
so it wasn't
really
clear to
what-
them, was it?
Mm,
Would you
Apparently
describe
not.
their questioning as outrage?
No, I
Were they
might,
angry?
I think it varied from questioning to angry.
Okay. Now,
Counselor.
you,
For rule, your counsel's objection.
Okay,
He
thank
was
you.
seeking clarification.
initially you were going to purchase the building from Mr. Thomas. Then someone brought up the idea, or maybe someone from Stone Mission told you that they would purchase the building from Mr. Thomas?
They didn't tell me, they told Mr. Thomas.
Okay, because you said that you were leasing the building from Stone Mission, but originally you were to purchase it from Mr. Thomas.
We were.
Then it became a lease from Stone Mission.
Correct,
Stone Mission was to buy the property from Mr. Thomas.
right,
That fell through at some point.
right.
And so then you went back to leasing the building from Mr.
Correct.
Thomas. Okay.
This was all reported in our reports, our
Uh-huh.
grant reports.
Uh-huh. Now, you mentioned this letter from I guess, Mr. Lenzini to Mr. Wright, the state's attorney in Logan County. I guess the state's attorney's office raised these questions with you
Yes, the
on
state.
behalf of the citizens of
I
Atlanta?
assume so. Yeah.
Okay.
We received, as I reported earlier, I think, the letter on dated the 22nd of August. It was a FOIA request from the state's attorney. And then on September 29th, he wrote a letter to Mr. Lenzini, to which Mr. Lenzini prepared a response. Once again,
That was never sent, correct?
that was never sent, because that was the time we
Excuse me,
decided.
Madam Counsel, I rule that was inadmissible. If you're gonna go ahead and open the door to it, then I'm gonna allow both parties to inquire.
Yeah, I believe
on this
that they
witness.
asked Ms. the
Then
witness
we'll just
questions
open the
about the
letter for
letter.
inquiry by both parties.
Okay, the letter was never sent.
Correct. No, because by that time, we had already received the notification of the building being donated.
So, Mr. Thomas told you he was gonna give it to you?
Objection. What do you mean by you?
What was the question?
Ma'am, you said you had received notification.
No,
Hold on a second, hold on a
Ma'am,
second.
stop talking. There was an objection. What was your objection, counsel? I want to make sure I get that.
Sure. The objection was form.
No, okay. Overruled. Go ahead,
Okay.
Mr. Hall.
Did you not say that you had received notification, or we had received notification that the building was going to be donated?
Mr. Thomas notified our president that he planned to donate the building, and our president announced that at our October 12th board meeting.
Okay, and that was done in this gift deed was issued on 16 November 2017. This is, let me show you what's been marked as Secretary of State Exhibit number 13. That's a photograph or a copy of a photograph of the building, correct? Mm-hmm. And is all that the Union Hall building, or is part of it?
This part right here.
And the other part is the museum?
The other part is called the Downey Building, and it houses the museum.
Okay. And is this an accurate representation of the floor plan of the building? First and second floor, is that right?
Yes. Looks to be the one.
Now, is that just the Union Hall building?
That's just Union Hall building.
Now, these open spaces here on both floors, those are open to the public? Anybody can go in?
Well, they're not open to the public right now because we haven't finished the implementation of the grant. They're open to the public when we host an event there and invite the public in. But
Okay, so the public has to be invited.
at the moment, because like I said, we haven't finished the work that will enable it to be staffed and ready and functional as program space.
All right, and does Mr. Thomas still have an office on the second floor?
Okay. Objection. Beyond the scope. We never went into Mr.
I can
Thomas's
call her as a
office.
witness and get her to answer the question, or we can just let her answer the question.
Go ahead. I think it's relevant. Overruled.
Ma'am, is Mr. Thomas' office on the second floor up here in the, it's called the office space area?
Currently, yes.
Okay, I don't think I have any questions.
You concluded, Mr. Hall.
I don't have any other questions.
Counsel, redirect.
Director is organization that uses that space.
Okay. Ms. Macchiarello, I just have a couple questions on redirect. You noted that Mr. Thomas leases space in that building, is that correct? In the Union Hall building, is that correct?
Does he lease space?
Yes.
Currently, no.
Okay.
Because, because we was determined by our attorney that that would be conflict, so he doesn't lease space.
Okay. And do you know, are you familiar with the Logan County Economic Development Board?
Yeah,
Okay. And do you know whether Mr. Thomas has a position in that?
yes, he does.
Do you know what that position is?
I'm not sure what the title is, but he's like executive director.
Okay. And does he have an office in, does the Logan County Economic Development Board have an office in the Union Hall building?
Well, Mr. Thomas works for them, and that's the work he does in that office.
Okay.
So it
Okay.
is for them.
All right. Okay. I have nothing.
Ma'am, you're aware of that Mr. Thomas owns a business called Teleologic or something like that?
He did, I don't know the status honestly of that.
Isn't it true that
LLC.
that the Teleologic office was in this building as well?
It was up until the point that the building was, I mean, honestly, that timing, I don't know. He did have an office in that building at one point,
Very good.
under that business.
Very
But
good.
I don't know when that business ceased to be TLA Lodge.
Okay, very good, thank you.
Thank you. Anything further, Councilman?
No, Mr. Foreman.
Thank you. Thank you, Ken. Does either of you have any additional questions or anticipate calling this young lady back?
I do not.
And ma'am, they don't plan. Mr. Laurel, do you see me? So you're welcome to stay, ma'am, if you wish.
Okay.
But you are.
Thank you for testifying.
Okay.
Thank you.
You can say.
Okay, did we want to go into closing arguments then?
Yeah, if you're finished with your evidence, the Secretary of State doesn't have any other evidence to present,
Nothing,
other
Mr.
than our exhibits. I believe we've moved the admission of the
So you have to
exhibits.
conclude your testimony then, your witnesses?
Or the minutes of the October 12th agreement shows they rescinded the leases and announced the donation of the building.
Oh, okay. I'm not sure. Mr. Laurel, do you know whether this was admitted into evidence, the October 12th? That was not one of our exhibits, but, actually, I don't have a copy of it. Okay, so it looks like that was admitted into evidence. Okay, we have nothing more to introduce into evidence. Rest.
You understand?
Yes.
Mr. Laurel, anything, any rebuttal, any cross-examination, any witnesses?
No,
Nothing?
nothing
Thank you,
other than
sir.
our exhibits.
Thank you, sir. All right. Counsel, you wish to make a closing statement then?
Yes, Mr. Foreman.
Please proceed.
So I want to jump right into addressing their point that there was no contract that existed between the secretary and the library for the Live and Learn Grant Funds agreement. Mr. Foreman, I just don't believe that this is the case. This is a clear case when promissory estoppel existed to create a contract between the library and the state for the provision of the Live and Learn grant. And I can provide you a brief of this with this case law if you like, Mr. Foreman, but promissory estoppel exists to enforce promises that do not meet the consideration requirement of a contract. To establish a claim based on promissory estoppel, a party must allege and prove, one, that an unambiguous promise was made to that party. 2, the party relied on this promise. 3, this reliance was expected and foreseeable. And 4, the party relied on this promise to its detriment. Mr. Foreman, each one of these 4 factors has been established here to show that promissory estoppel created a contract between these parties. Clearly, the library relied on the promise to receive these grant funds. As both witnesses testified, they set about their whole budget and their programming goals on the receipt of these funds to renovate the Union Hall building, which was going to provide an integral part of the library's purpose and mission going forward. Clearly, there was an unambiguous promise made here by the secretary to the library. I mean, there was a grant agreement, the money was given. As I mentioned before, the library relied on this promise. This reliance was certainly expected and foreseeable. The secretary wouldn't have provided the grant if it didn't think that the library was going to rely on it and use it to benefit the public. So this is a case where promissory estoppel exists to create a contract between the library and the state for the provision of these funds. And as a result of that, a creation of the contract, the common law contract offenses that I mentioned earlier, including the ability to cure a breach, apply here. So just to go over our argument again, there are two bases for why the library should not have to repay the grant funds. First of all, there's no evidence that the library ever violated any of the grant funds terms. They haven't proven that their theory is correct, that the lease between the library and the Union Hall building was void. I mean, they've provided no evidence that this lease was ever voided. They've provided no evidence that Mr. Thomas was ever convicted of violating the Public Officer Prohibited Activities Act, or that anything was done to void this lease. So their entire theory just doesn't wash, Mr. Foreman. The library has done everything it has been required to do under the terms of the grant. It has maintained a long-term lease and ownership of the building. Again, going into some of the law as to why the library had the legal right to cure its breach of the contract, as I mentioned before, even if they did prove that the library its agreement with the Union Hall building to lease it was void, the library clearly cured it. There's a case that I referenced in our response to the motion for a bill of particulars. And that case is entitled Stanley Yudka Sales Co. versus Lacey Forest Products Company, 915 F2 273, 7th Circuit, 1990. In that case, the court noted that a party has a right to cure a material breach of a contract, stating that an opportunity to cure in circumstances similar to the case, this requirement comports with general contract theory, and we agree with the district court's decision imposing this requirement on the non-breaching party. Additionally, the right of a non-breaching party to cure a material breach of a contract has been recognized by the Second Restatement of Contracts, and this is all explained in my response to the motion for the bill of particulars in more detail.
Which council, I don't have a copy of that.
Oh, okay.
I have the
It's part
response
of
to
the-
the admission of facts, but not
Okay, yes, and this is the case law I'm referring to in particular, right there, yes. So not only does the Second Restatement of Contracts note that there's a right to, a party has a right to cure a breach of the contract, and the Second Restatement of Contracts is notable because Illinois courts customarily follow the Second Restatement of Contracts. A number of other secondary sources recognize the right to cure a breach of a contract. Farnsworth on contracts, Corbin on contracts. And some of the things, a party has a right to cure a material breach of a contract when that breach is not total, substantial, and defeats the object of the contract. Here, as I mentioned before, if there was a breach, it was certainly not total, it was not substantial, and it did not defeat the purpose of the contract. The grant funds were used to renovate the building. The library worked in good faith to cure any potential breach of the contract terms that might have existed. Right after finding out that the secretary wanted them to repay the grant funds, the donated the library, the Union Hall building, to the library. So the library now is satisfying the requirements of the Live and Learn construction grant. Mr. Thomas resigned from the Board of Trustees. So they acted swiftly to cure the breach of contract. Good faith is another one of the defenses that has been recognized as relevant to determining whether a party cured the breach of the contract. And finally, Your Honor, or Mr. Foreman, I just want you to keep in mind here that the Atlanta Public Library is a small library. It has a small budget. $25,000 is a lot of money for it. It did not purposely do anything wrong here. It was put in this situation, frankly, by bad legal advice from its former attorney. And it's not fair to either the library district or the residents of Atlanta that it be prejudiced more than it already has been by being forced to repay this grant. So that's all I have.
Thank you, Counsel. Mr. Worrell, did you have any summation?
Yes, please. The library district did not ask for legal advice until well after they had filed the application and recognized that they were in trouble. They made an application, and it's the application, the documents regarding this application that are in evidence, which are establish the four corners of this proceeding. Promissory estoppel and the second restatement of contracts has nothing to do with this proceeding. There is no contract between the Secretary of State and the Library District. They filed an application, and the Secretary finding without knowledge that part of the agreement involved this sweet deal between Mr. Thomas and the Library District, granted them the money. It's kind of like a person goes to the Secretary of State's office and files an application or makes application for a driver's license. And then they get the license because they've done what they need to do, like pass the test. And then later they violate the law. They're convicted of driving under the influence, and their driving privileges are revoked. Same thing here. The Library District violated the law from the beginning, entering into their contract with Mr. Thomas, knowing that he owned the building they were going to lease or buy from him while he's a member of the board. The legislature did not intend for the restatement of contracts to be a part of this scheme, the legislative scheme. I mean, there's nothing in the law or the act, the Public Officer Prohibited Activities Act, which suggests that the restatement of contracts should be considered in deciding whether there was a violation of the act. There's nothing in the act about some promissory estoppel. The plain language of the act takes precedence, as does the plain language of the application. Section 3 says, no person holding any office, either by election or appointment, under the laws or constitution of the state, may be in any manner financially interested directly in his own name or indirectly in the name of any other person, association, trust, or corporation, in any contract or the performance of any work in the making of a letting of which such officer may be called upon to act or vote. Any contract made and procured in violation hereof is void. Not may be void, may be voidable, will be void, is void, as the General Counsel stated ab initio. From the moment the agreement was entered into, the contract was entered into by the Library District and Mr. Thomas, it was void because he had an interest, an economic interest in the contract, and he was a member, an officer of the Library District. Perhaps the most important language in the statute is in section 3.1. This section shall be liberally construed to accomplish the purpose of requiring the identification of the actual parties benefiting from any transaction with a governmental unit or agency involving the procurement of the ownership or use of real property thereby. People of Atlanta knew there was something wrong when they found out about this. And then the library figured it out on their own. Whether they had any intent to violate the law is irrelevant. The statute does not say anything about there having to be intent. The act occurred, and from its from the moment the contract was signed, it was void because it was illegal. Because Mr. Thomas, being an officer of the board, had a financial interest in the contract. That's all that's involved here. Thank you.
Thank you, Mr. Hall. Response?
In terms of in terms of a response, I mean, I think the case law speaks for itself. Promissory estoppel exists to create a contract here between the parties, and they haven't proven that the lease agreement between the Union Hall building and or the lease agreement for the Union Hall building was void. I mean, that's the thing to take away here. They have not proven that the lease agreement for the Union Hall building was void, so there has never been a breach of the grant terms. That's all. Thank you.
Thank you. Thank you. Gentlemen, this matter is completed. Can I get something out as quickly as possible? Mr. DeCiano, you had mentioned earlier, if either party wishes to send me law, that's fine. I don't expect it.
Okay.
I probably don't need it, but having said what you said for many years, if you want to send something, go ahead.
Okay.
Thank you.
I might take you up on that. Thank you.